Good day, students. Welcome to Administrative Law. Before we go to the technical aspect of administrative law, let us go first to the general principles. Prior to this lecture, I ask you to define what is administrative law and the importance of this branch of law. I hope you did not just look for its definition in the internet without at least trying to understand what it is. Furthermore, your answer as to its importance must be based on your analysis from its given definition and not just a copy-paste from the internet. If you've done the latter, that is not your answer, but the answer of whoever posted it on the internet. These basic exercises actually would let the professors easily identify if your answer is just copy-pasted. It is actually a trap, and you will be given a demerit for that. So let's start. What is administrative law? Administrative law is a branch of public law which fixes the organization and determines the competence of administrative authorities and indicates to the individual remedies for the violation of rights. Administrative law in actual practice in the Philippines is a branch of public law. When you say that it is a branch of public law, it means that it governs relationships between legal persons and the government, between different institutions within a state, between different branches of the government, and relationships between persons that are of direct concern to society. Why legal persons? Because under the law, we have natural persons like us individuals, you and me, and juridical persons like corporations. When you say different branches of the government, we have the executive, legislative, and the judiciary. Now, number two, it deals with the activities of executive or administrative agencies, known and referred to as boards, bureaus, commissions, authority, offices, and administration. Since we are still in the introduction, think of agencies of the government which are referred to with these terms. Boards like the Land Transportation Franchising Regulatory Board or the LTFRB. Bureaus like the Bureau of Internal Revenue or the BIR. Commissions like the Commission on Elections and many more. Now, number three, these boards, bureaus, commissions, authority, offices, and administration can exercise quasi-legislative and quasi-judicial powers and functions in the sense that they can issue rules and regulations not contrary to the guidelines set up by law, and they can solve the issues or the cases submitted to them. Number four, administrative regulations and policies enacted by administrative bodies to interpret the law which they are entrusted to enforce have the force of law, are entitled to great respect. They have in their favor a presumption of legality. For example, courts do not interfere with the administrative action prior to its completion or finality. What does that mean? Imagine if prior to completion or finality of administrative action, courts will interfere. No act of the executive or administrative agencies will be finished or completed if there are too many complaints in court. All administrative acts are presumed legal since they have been given the power under the law to exercise administrative actions. Only upon its completion or finality, or when it is on its face unconstitutional, that they can be interfered by the courts. So as a general rule, courts do not interfere with administrative action prior to its completion or finality, except those provided by law. Number five, in the resolution of cases or issues presented to administrative bodies and offices, they are not bound by the indispensable in administrative cases. Number six, an administrative decision may properly be amended or set aside only upon clear showing that the administrative official or tribunal has acted with grave abuse of discretion amounting to lack or excess of jurisdiction. When you say that there is grave abuse of discretion amounting to lack or excess of jurisdiction, the Supreme Court time and again set a guideline to follow for this. So what does this mean? This term, grave abuse of discretion amounting to lack or excess of jurisdiction. The Supreme Court said that there is an abuse of discretion when the same was performed in a capricious or whimsical exercise of judgment, which is equivalent to lack of jurisdiction. The abuse must be so patent and gross as to amount to an evasion of positive duty or to a virtual refusal to perform a duty enjoined by law, such as when the power is exercised in an arbitrary or despotic manner by reason of passion or personal hostility. This was enunciated by the Supreme Court in the case of heirs of Tan Juan versus the Office of the President et al. For example, a sangguniang panlunsod can only exercise their power and function over the scope of their jurisdiction, or in this case, in their city or municipality. They cannot capriciously exercise power over another city or municipality. Number 7. Factual findings of administrative bodies should be accorded not only respect but also finality if they are supported by substantial evidence, even if not overwhelming or preponderant. Again, this is in line with the principle that administrative acts are presumed legal or constitutional. Number 8. Although findings of facts of an administrative agency is persuasive in courts and carries with it a strong presumption of correctness, nonetheless, the interpretation and application of laws is the court's prerogative. This is now the limitation of administrative actions. Again, as a general rule, the administrative actions are presumed legal and constitutional. But when they attain finality or completeness, an action can now be brought into court. So when they attain finality or completeness, the same can now be reviewed by the courts given that there is a complaint. Because if there is no complaint, there is no problem, so to speak, to be solved by the courts. So there must be a proper complaint. So while the court is still scrutinizing to come into conclusion as to the constitutionality or legality of administrative acts, pending finality of the decision of the court, administrative actions will still be presumed legal. However, when the court declares that an administrative action is contrary to law, then it will be declared unlawful and illegal. Hence, the administrative action will be undone. With the doctrine of separation of powers, it is within the ambit of the judiciary to interpret laws. We will have more illustrations about this later on. Let's proceed first to number 9. Administrative remedies should first be exhausted before filing a petition for relief. This is an elementary rule under the law. In the course of Wallstrom versus Mapa Jr., this is very important, class. The rule says to exhaust first administrative remedies before filing an action in court. I will give you an example which is very relatable to this principle. Let's say, for example, may nag-away and the other got injured and needed a medical attention for, let's say, 1 to 9 days. Under the law, the crime committed is slight physical injuries. Since the penalty for this is imprisonment which do not exceed 1 year or a fine not exceeding 5,000 pesos, the law requires barangay conciliation. In layman's term, maghusay usa sa barangay. This barangay conciliation or husay sa barangay is an administrative remedy which is mandatory. Again, The principle is to exhaust first the administrative remedies before filing a case in court. Now, what will happen if you file an action directly to court without first having the husay sa barangay? The court will remand, ibabalik yan, the case to the barangay for barangay conciliation. Ibabalik yan doon sa barangay and the court will say that there is failure of complying the requirement of exhaustion of administrative remedies. That's it. Number 10. On purely legal question, however, the aggrieved party needs not exhaust administrative nature to be done or can be done in administrative forum. This one is an exception to the rule on exhaustion of administrative remedies. As I said, we have general rule, we have exceptions, but we only have exceptions if the rule provides for these exceptions. If the question is legal and not factual, you can go directly to court. You need not exhaust administrative remedy anymore. Now, what is a legal question? It is when there is doubt as to what law is to be applied on a certain set of facts. Ang tanong tama ba yung batas na ginamit? Hindi yung tanong na, totoo bang nangyari at tama ba yung nangyari? That is not a question when we say question, legal question or question of law. So the question is, tama ba ang batas na ginamit? Now 11. If a case is such that its determination requires the expertise, specialized skills, and knowledge of the proper administrative bodies, because technical matters or intricate questions of facts are involved, then relief must first be obtained in an administrative proceeding before a remedy will be supplied by the courts, even though the matter is within the proper jurisdiction of a court. This is enunciated by the Supreme Court in the case of Industrial Enterprises Incorporation versus the Court of Appeals. This is known as the principle of primary jurisdiction. Now let us trace the origin of administrative law. First, statutes. Setting up administrative authorities either by creating boards and commissions or administrative officers or by confiding the powers and duties to existing boards, commissions, or offices to amplify, apply, execute, and supervise the operation of and determine controversies arising under particular laws in the enactment of which the legislature decided for matters of convenience or for quicker or more efficient administration to withhold the controversies at least in the first instance from the courts of law. Number 2, increase of government functions and concerns. Complexities of modern life necessarily increase the functions and concerns of government, which in turn requires the legislature to create more administrative agencies which will take charge in attending to matters that demand their special competence and expertise. As you can notice, every board, bureau, or commission has a certain, specific task to be put into action. Now, number 3, necessity of government control and regulation. The government has intervened in contractual relations that are affected with public interest. As it is now, the government has exercised control and regulation of many aspects of business such as, but not limited to what? Labor and management relations. For that, we have the Department of Labor and Employment, immigration and deportation, banking, recruitment of overseas workers, insurance, finance, foreign exchange, health, regulation of profession, regulation of sports activities, including the monitoring of players' credentials and citizenship, investment, energy regulation, election, tax collection and administration, human settlements and regulation of subdivisions, civil service and eligibility of government employees, and many other businesses and activities that are impressed with public interest. As you can notice, in this enumeration, they are all impressed with public interest. That's why the intervention of the government through administrative bodies is very important. Now, we have traced already the origin of administrative law. Now, what are the sources of administrative law? First source of administrative law is our Constitution. In Article 9, Section 1 of the 1987 Constitution, it provides that the constitutional commissions, which shall be independent, are the Civil Service Commission, the Commission on Elections, and the Commission on Audit. Take note of these three constitutional commissions because they are exclusive. The Commission on Human Rights is not included. So when I ask you what are the three constitutional commissions, these are the constitutional commissions. What again are they? Civil Service Commission, Commission on Elections, and the Commission on Audit. While Commission on Human Rights has commission in its name, it is not a constitutional commission in its strict sense. Now, the second source of administrative law, statutes creating administrative bodies. So what is the example for that? We have the Board of Energy, which was created by what? Presidential Decree number 1208, dated October 6, 1977. Third source of law, we have court decisions. When we say court decisions, it is not actually the decision of the lower courts like the municipal trial courts and the regional trial courts, neither the decision of the Court of Appeals, but the decision of the Supreme Court. Interpreting the charters of administrative agencies and defining their powers and responsibilities. Again, as I said in the earlier part of our lecture, pending completeness or finality of an administrative action, they are presumed legal and constitutional. But when it attains finality and completeness, they can be checked by the courts when there is a complaint. And therefore, their acts may be declared by the courts as unconstitutional or illegal, or not within the ambit of their powers. Now, fourth source, the body of rules, regulations, and orders issued by administrative agencies. Perhaps when we made mention of board, bureaus, commissions, and many more in the earlier part of this lecture, some administrative agencies came to your mind already. Now let us enumerate concrete examples of these administrative bodies, and you will be shocked that there are too many of them, actually. Now, what are the administrative bodies and agencies in the Philippines? They are grouped into 6. First, we have administrative bodies for regulation under police power. So, what are these administrative bodies? First, we have the Commission on Immigration and Deportation. Now, if you have unwanted aliens in the Philippines, they can be deported. Or if they are already overstaying in the Philippines because their visa is just a tourist visa, they can be deported or will be returned back to their country. We have the Securities and Exchange Commission. This commission concerns with the creation of corporations. Now, if you want your corporation to have the power and effect of a juridical entity, you register it with the Securities and Exchange Commission. We have the Professional Regulation Commission, which all professions except for lawyers are covered by the Professional Regulation Commission. The lawyers are not covered by PRC. We are governed under the discipline of the Supreme Court. Now, the fourth one, the Bureau of Food and Drug. Next, Housing and Land Use Regulatory Board, HLURB. Maybe it's your first time to hear this, but if you want to build a subdivision, for example, you need the Housing and Land Use Regulatory Board. We have the Board of Food Inspectors. We have the Monetary Board. And, of course, the Land Transportation Office. Yung kinatatakutan ng iba na kapag bumabiyahe, walang license or expired license or with an expired rehistro. Now, second group, administrative bodies for regulation of public utilities. We have the Land Transportation Franchising and Regulatory Board. They are, this is the administrative body which concerns with giving of franchises to public utilities like buses and public utility vehicles. We have public utility buses, we have public utility vans, and other public utility vehicles in cities or municipalities. You have the tricycles. But when it comes to buses and vans, you have the Land Transportation Franchising and Regulatory Board. And that is very strict actually, class. If you are given a franchise, yung franchise mo is to travel a route from, for example, Davao to Laak. You cannot pick passengers when you are traveling to another place. Malaki yung penalty niyan. So for example, if you are your van which has a franchise from Davao to Laak, hinire ng isang family to travel to Jensan. And going to Jensan, they stayed there and you came back to Davao region. And while you are traveling back to Davao region, you picked up passengers. That is not allowed because your franchise is just from Davao to Laak. And you will be penalized for that. And I think the penalty is hundreds of thousands. Now, the second one, National Telecommunications Commission. We have the Board of Energy. We have the National Water and Resources Council. We have the Civil Aeronautics Board. And we have the Board of Marine Inquiry. Third group, administrative bodies to carry on governmental functions. We have the very famous, the Bureau of Internal Revenue, because taxes or tax is the lifeblood of the state. It is the lubricant for the machineries of the state. We have the Bureau of Customs. We have the Civil Service Commission, which also disciplines erring public servants. We have the Board of Special Inquiry. We have the Board of Lands, and we have the Land Registration Authority. Fourth group, administrative bodies that adjudicates and decides industrial controversies. We have the National Labor Relations Commission, or the NLRC. We have the Philippine Overseas Employment Adjudication Office. We have the Human Settlement Regulatory Commission, or the Housing and Land Use Regulatory Board. Fifth group, administrative bodies making the government a private party. We have the COA, one of the constitutional commissions. Do you remember? What are the three constitutional commissions again? We have the Civil Service Commission, Commission on Elections, and the Commission on Audit. Now here, one of the administrative bodies making the government a private party, we have the Commission on Audit. And the second one, we have the Social Security System Adjudication Office. Sixth group, we have administrative bodies that grant privileges. We have the Philippine Veteran Affairs Office. We have the Board of Pardons and Parole. We have the Bureau of Lands. And we have, again, the LTFRB. Because a franchise is just a privilege and not a right. Now, in the case of PLDT versus City of Bacolod, the Supreme Court ruled that the Bureau of Local Government Finance are under the Department of Finance, which is under the Department of Finance, is not an administrative agency whose findings on questions of facts are given weight by the courts. So with these enumerations of bureaus, offices, and commissions, how many of them are you familiar with? maybe perhaps a few of them. But of course, you know the BIR, the LTO, and the LTFRB perhaps. Now, we have been talking about administrative law, but we have not yet defined what is the definition of administration per se. Administration as it is. According to Goodnow, administration is defined as an activity of the executive officer of the government. The government, the government administers when it appoints an officer, instructs its diplomatic agents, assesses and collects its taxes, drills its army, investigated a case of the commission of crime, and executed the judgment of court. Whenever we see the government in action as opposed to deliberation or the rendering of judicial decision, there we say is administration. Administration is thus to be found in all the manifestation of executive action. Administration, as it is presently understood, refers to the aggregate of those persons in whose hands the reins of the government are for the time being. Now that we have defined what is administration, let us discuss the aspects of administration. In our lecture, we have two aspects of administration. First, the internal administration, and the second, external administration. Now, what is internal administration? Internal administration includes the legal structure or organization of public administration and the legal aspect of its institutional activity. For example, the personnel, material, physical, and planning activities. These are the basic key aspects of administration. Now, what is external administration? External administration, on the other hand, is concerned with the problems of administrative regulations or the exercise of power for carrying out the ends for which such powers were delegated. When you now have the people needed to execute what you have planned, as well as the materials needed for its execution, there will definitely be problems which will exist in the execution or in the carrying out of its power delegated to it. Let us cite as example the power of the government to expropriate, or the power of the government to take private property for public use, of course with payment of the value of the property taken. That power is expressly stated in the Constitution, and this power of the government is delegated to the local government. There is no problem with the question, can the government take a private property for public use for just compensation? Because the answer will always be yes, according to the Constitution. But when there is a legal wrong in the act of taking of the private property, for example, the person who entered the private property is not from the government and he has no legal authority, there now exists a problem in the administrative aspect. Thus, the act of taking will be invalidated. We will end here. On the next lecture, we will distinguish administration from other legal terms which might have interchangeably used to some other terms. We will also dissect the strengths and weaknesses of administrative actions. Thank you for listening, and that's all for today's lecture.